while we're waiting for Senator Greenleaf to come, I wanted to just again express my appreciation. I think it was a wonderful and very interesting discussion about conviction review. And for me, it highlighted some of the difficult choices that sometimes arise when we're thinking about how to improve our criminal justice system. And the topic that we have to talk about today is one that I think also in certain communities, many communities, both here locally and throughout the country, can at times face us with difficult choices. I don't think I have to convince the people here in this room that indigent defense, if we think about the entire criminal justice system, is a very significant and important component. We know that the vast majority of criminal defendants aren't going to have the means to pay for their own defense, and so they're going to be reliant upon us as citizens in our legal system to provide vigorous defense for them. And so what we want to talk about today is what we need to do in order to ensure that there's sufficient resources in order to address that need and enable indigent offenders to be able to do their part in the system in order to ensure integrity. Fortunately, you're not going to have to hear very much from me. I view my job as the moderator is to let the talent speak, and we've been able to put together really an outstanding group of thoughtful individuals who can tell us more about this topic. So let me just give a moment. You can find full biographies of each of these folks in your program, but it's my pleasure to first introduce to my immediate right my colleague here at Penn Law, David Rudovsky. David is a nationally renowned civil rights attorney. He's a decorated teacher, a MacArthur Award winner, a outstanding advocate across a variety of civil rights related issues. Most notably recently, he successfully argued before the Pennsylvania Supreme Court a case which for the first time established here in Pennsylvania a presumptive cause of action for ineffective assistance of counsel due to insufficient funding, representing a small rural county in the state where they just have enormous caseloads. And he'll perhaps talk about more about that experience. So it's great to have you with us, David. So to David's right, we have Phil Kohn. Phil is the head defender in Clark County, Nevada, where Las Vegas is. Phil has varied and extensive experience both as a public defender, but he's also worked, had a period of his career where he served as a prosecutor as well. So he brings both of those perspectives, and he's participated in a number of our events and been able to just bring outstanding perspectives to a range of issues. And we're excited to hear from you about this issue of indigent defense. And then we'll introduce the senator if he arrives. I'll skip over to Derwyn Bunton. Derwyn Bunton is the chief defender in the Orleans Public Defender Association. Come on down. We're just doing some introductions. Thank you. So Derwyn has become a national voice on the issue of indigent defense. Due in part to a very principled, but I would think it's fair to say in some quarters controversial decision last year to refuse taking certain types of cases as a result of the enormous caseloads facing Derwyn and his staff in New Orleans. And we'll have a conversation about what's happened there and what has led to those conditions. And then finally to Derwyn's left, we're very pleased to welcome Senator Stuart Greenleaf. We're very proud that Senator Greenleaf is an alumnus of Penn, so welcome back to the university. It's great to have you here. Senator Greenleaf has varied experience both as an advocate. He helped to establish the first public defender office in Bucks County, so he's worked as a public defender. He's also worked as a prosecutor, had service in local government in the Pennsylvania House since 1979, represented I want to say the 12th district, as a Pennsylvania state senator, and he currently leads the Senate Judiciary Committee. So extensive experience working in the criminal justice system as a legislator, thinking about policy issues. The entire time I've been alive, he's been pushing criminal justice reform and has authored dozens of bills on various criminal justice issues. So our format is we're just going to have a conversation today. And the way I'd like to start the conversation out, so some of you may have seen actually this past Sunday evening on 60 Minutes, there was a very interesting feature on Derwyn and the Orleans public defenders and their situation there. Of course, the larger theme that we have for our conversation is preventing error, and to kind of connect this issue of indigent defense to the topic of error, I want to just show a brief clip from that 60 Minutes episode.
We sat down with 9 current and former New Orleans public defenders who all admit they simply do not have the time or the budget to adequately represent all their clients.
How many of you believe that an innocent client went to jail because you didn't have enough time to spend on their case? All of you. You feel you've all had that experience?
We simply don't have the time. We don't have the money. We don't have the attention to be able to give to every single person.
It's not.
So, for someone like me who helps to lead an organization that thinks about preventing error, Derwyn, this is deeply troubling. And I think if we were to have people who have been defenders in this room stand up and ask a similar question, my sense is that we would get some similar responses. So help me understand, how is it that we've gotten to this situation in New Orleans?
Well, I think in New Orleans, we're unique in a lot of ways, but we're also very much typical in a lot of ways. And when you talk about public defense, I think across the country you see resource-strapped public defenders, and not everywhere, but in a lot of places, and I would dare to say most places. And so what has happened is our criminal justice system has become so large and so far-reaching that there's simply too many people coming through the system, and a system that has over time been built to put people in jail. And so the resources that don't go to public defense is a part of a system that's designed to put people in jail. And so the way it works, and what I think what you witnessed with some of my staff, is the realization, the very real work of it is that when someone's in jail, jail is a terrible place. And they're also looking at a system that is ready to send them to jail for the rest of their lives, particularly in Louisiana, where you can go to jail for the rest of your life and never have a violent offense ever committed. And so when you're sitting in jail and it's terrible, and they're telling you the deal is 5, or you could go to trial and lose and go to jail for the rest of your life, a lot of our clients are rational actors. They'll avoid the risk for the predictability of the 5 years, even though they did nothing wrong.
So you mentioned that in some ways New Orleans is unique, and in other ways you think it's representative. I'd be interested, David and Phil, in your thoughts. I mean, is this problem that we're seeing in the survey, is that consistent with things that you've observed in your own jurisdictions or other jurisdictions?
It's a national problem. I think there are more locations like New Orleans than the opposite. There are some very, very good models of public defender representation right here in Philadelphia, Washington, D.C., New York, Las Vegas. There are very good models. The federal model, federal public defenders are well-funded. They're adequate to their task. That's a good model. But I would say it's probably 85% of the jurisdictions in this country, they are underfunded for all the reasons we know. It's the politically least popular thing to fund. If you're running a county or a state government and you've got concerns about transportation and education and economic development, the last thing you're going to do on your budget line is how many public defenders you're going to have. Regardless of the explosion of cases and the number of cases they have to handle, that's the last thing that's going to get funded. Certainly prosecutors are going to be advantageous in that situation, not public defenders. And when you look at just some of the data, I mean, it is overwhelming. Studies have been done across the country as to the caseloads defenders have. In some jurisdictions, single public defenders or individual public defenders in their offices are carrying 500, 600 cases at a time, 400 felonies, 200 misdemeanors. It is impossible. It is impossible to represent those people. Beyond that, they don't have social workers, investigators to help them. And so what you have is basically the plea mill that we talk about, right? That prosecutor offers a deal, and you kind of coerce your client to take that deal without any investigation, sometimes without the police paperwork. You don't even know how strong the case of the prosecutor is. And I say it and people say, no, that can't be the situation, right? And it's true. So let me just talk 1 minute about, because with the same situation that you had in New Orleans, the case that Paul mentioned in Pennsylvania, Luzerne County, the public defender there, a guy named Al Flora, and again, most public defenders are public appointees. They're under the control of the local government, either the state government or the county government. Philadelphia is different. We have an independent nonprofit that's a defender, and that gives us some political, power in terms of not being controlled by city government. But most public defenders are public defenders. They're appointed and work at the will of the county. Al Flora, after many years, decided too few lawyers, too many cases. He literally could not provide adequate representation, and several years ago told the county commissioners that he would refuse new cases until he got more funding. They refused to give it to him. He refused cases, and then we came in, and he became a lead plaintiff in a case against the county, trying to establish the principle, which is not an easy one legally, to say that an ineffective assistance of counsel claim can be brought before trial. You don't have to show after trial that the lawyer didn't do the right thing. If there's systemic flaws, systemic underfunding, we should know that we can't predict which defendant will receive ineffectiveness, but we'll know a significant number are. That case went through the state courts, and as Paul mentioned, we had a very good ruling last year from the state Supreme Court in a case called Kohn versus Luzerne County, saying that those allegations state a claim. And that reflects cases around the country. There are now a half dozen state Supreme Courts that have said the same thing. And I would say the analysis, not only that there's a Sixth Amendment right, but lawyers have a professional responsibility under the rules of professional conduct in many jurisdictions, in virtually every jurisdiction, not to get engaged in litigation in which you can't do an effective job. That's true for every lawyer, not just private lawyers. It's true for prosecutors. It's true for public defenders. You have an ethical responsibility not to represent a client when you don't have the resources or ability to represent that client. So the Supreme Court agreed with that. But just to show how this system works, Al Flora, right, who was the plaintiff in that case, who was the public defender, was then fired by the county. Clearly for his role as being the lead plaintiff in the case. We were able to get other plaintiffs. We got clients to substitute for him. He's now got a civil rights claim against the county for firing him for exercising his constitutional rights. But it's a case that in microcosm shows everything that goes wrong. Political control, lack of funding, retaliation when a lawyer does what the lawyer should do responsibly, and at least at that point, literally no judicial remedy. Now there's that remedy, but it's very difficult. I mean, that's a heavy burden of proof that we have. You need experts to show this ratio between lawyers and caseloads are impossible. Sure, there are ABA standards, but you've got to prove all that. Very expensive litigation. And in a place like Pennsylvania, which is true in most states, we've got 67 counties. Every county has its own public defender. So we're going to, and I would say you go across Pennsylvania, probably 3/4 of the offices are like Luzerne County, have the same problems. People haven't stepped forward to sue, but that's the problem. And to litigate that is a very, very difficult proposition. Put on top of that, that Pennsylvania is the only state in the country that has no state funding for defender services. It makes it even more complicated. But it's not just Luzerne County. It's not just Pennsylvania. I suspect that, as I say, without counting, 80% of the public defender offices you walk in today, maybe even more, you will find caseloads that are just staggering and make it impossible and lead to all the problems we've been talking about at this conference, right? The use of plea bargaining and lack of Brady turnover and so on. The defense service is so critical as a counterweight. If you don't have good defense lawyers, you will have an uneven, unfair, and oppressive system.
Well, thanks for raising that, David. I mean, that's, you've touched on a really rich vein of topics, and I hope we'll have a chance to return, kind of the judicial versus legislative remedies. I think there's a lot of issues about funding structures. But Phil, I wanted to hear from you. I mean, is your experience kind of consistent with what David and Derwyn are saying? I mean, tell me how Clark County or other counties in Nevada are or are not like this.
Well, Derwyn uses the terms unique and typical in terms of describing New Orleans, and I would certainly use those exact same words for Clark County, but for very, very different reasons. Typical in the fact that we certainly have more cases than I would like our deputies to have. Unique in the sense that New Orleans has had 300 years to get to this point that they are. Clark County has done this in 30. In 1985, Clark County had a population of just barely 500,000. In 2015, we are 2.2 million people. And so the county grew so incredibly fast that every agency is underfunded. We don't have income tax in Nevada. As a matter of fact, the only taxes we really raise in Nevada are when you all come to Nevada and stay at our casinos and play on our tables. That's where our tax comes from. So I have an advantage over other defenders in the state because the municipality in which the casinos reside is where those gaming taxes go. And Bugsy was really smart. He started that casino right outside the county line, not in the city, but in the county. And I work for the county. And so I live in one of the most wealthy counties in the country. But the fact is, we are all underfunded. It's not just the public defender's office, the DA's office, and worse yet, family services and CPS are terribly underfunded, and we are constantly dealing with children who are badly injured or killed. It is a real problem throughout Clark County. Twice I have advised the county that I can no longer take cases, but not because of just the staggering caseloads. We have this crazy situation where our judges are paid for and appointed by the state, and so they add judges based on population and the population growth, but there's no commensurate statute that helps grow the public defender or the DA's office. So we're constantly getting more courts, more places to appear, which stretch us terribly, but neither side is well funded. And so part of, or the theme of this meeting is about finding common ground. And the reason why I've not really been forced out or I serve at the will of the county commission is because the two times that I've quit taking cases, it's because of the more judges. And we've got together with our DA's office this year and say, hey, we both have the same problem. We both have to go to this new court, and you didn't provide for it. And what's worse, the judges are on a regular calendar, so they started on January 3rd or 4th, whatever that date was, and the county budget won't be approved until sometimes next month, and whatever new bodies I receive or the DA will receive will happen July 1st. So we have a 6-month gap, and I've just said, we're not taking them. The DA's office is stuck, they have to do it. But also in finding common ground, where we've been successful is the county finally recognizes that the jail is an incredibly expensive proposition. Our jail costs the county over $300 million a year. What really led to my getting more support from the county was in fiscal year 15, the Sheriff's Department also gave the county a $25 million bill for overtime in the jail. And we had some meetings about that, and after one meeting with the county manager and I were sitting around, and we were trying to figure out how we can get 700 people out of jail. Just get them out. Misdemeanors, low felonies don't belong. And we're sitting around talking, and he says to me, you know, I hope it doesn't trouble you that our motives in getting the people out of jail are probably different. I said, Don, I really don't care what your motives are. We found a common purpose, and we were able to, with the DA's office and a little bit with the courts, get 700 people out of jail and close a wing of the jail to not have another $25 million proposition. So we've been able to work together over the last couple of years pretty well. And I think that's the only way we're in a position where we really feel that we can service our clients in a way that we feel is ethical and appropriate.
Thanks for sharing that experience. I mean, I think it's really interesting because, you know, David has begun to point out some of the political challenges, the lack of awareness. You've identified, well, hey, here's one area where, you know, maybe people who might have some different ideological views with respect to crime can come together in terms of the fiscal stuff. I'd be interested, Senator Greenleaf, in your perspective. You've obviously had rich experience in, you know, trying to think about and bring people together over issues. I mean, does what Phil says resonate? I mean, do you think that the cost of jails is one way to bring people together? How do we deal with some of the political obstacles here?
Well, first of all, thank you for giving me the opportunity to be here today and your invitation. And also, my colleagues on this panel are active practitioners now. I still practice law, but they're in the midst of it every day. I'm dealing with the policy issues now. So I respect their opinions and their experience, and their experience is true. And it's a common experience, not just in their states, but in Pennsylvania as well. I'd like to just tell you a little story, and it's not going to make me look so good, but it's the truth, and I think it's a process that I've gone through, and many others, and I think our country is going through now. I call it's my road to Damascus experience, and I was in the public defender's office for a couple of years, and then went into the DA's office in Montgomery County. I was chief of appeals there, and I also tried cases, murder cases, both defense and prosecution, and tried every kind of case you could think of, every major felony cases and things like that. So when I went into the legislature and had the opportunity to be there, I wanted to be the chairman of the Judiciary Committee. I don't want to be president pro tem or anything like that. I want to be the chairman of the Judiciary Committee. And thank God I was appointed to that soon after I was elected to the Pennsylvania Senate. And I came there with a tough on crime attitude because that was the model. That was the model in Pennsylvania. That was the model in Montgomery County, where I was a prosecutor. That was a model nationwide, that the tougher we got, the safer our streets would be, and we would fulfill our duties as prosecutors to accomplish what law enforcement should be doing. It sounded like a good idea, and so I went in there with a lot of relish of trying to introduce bills. I'm the author of a lot of the mandatories we have now. I'm the author of all the drug offenses. When we introduced those legislation, we thought we were getting at the big dealers. I didn't know what a large amount of marijuana was, quite frankly, so I relied on the DAs to tell us. Well, I'm sure it wasn't intentional, but what we passed and what I passed were mandatories that applied to small amounts too, and was not going after the big dealers at all. We passed tough on crime legislations, restructuring out what everybody else was doing. And we thought we were really accomplishing something. And so I did that for about 20 years. And in 2000, one of my colleagues who was against the death penalty asked me to hold a hearing on that issue. So as a courtesy to him, I did. And it was a long one. It was like, I remember being a very lengthy time there. And those people who were opposed to the death penalty kept saying, you have to give, we have convicted innocent people here, so we have to be careful. And I said, no way. Pennsylvania, we never convicted an innocent person in Pennsylvania. I was there. I know how we vetted the case. If we ever found that someone was not guilty, we would take steps. I remember having a case like that, a rape case, and I was outraged by the rape of this young lady. So I spent hours preparing the case to get this guy. And the more I looked into it, the more I had questions about whether there was such an event that occurred. And it turned out that it had not, so we took care of that. So we don't prosecute innocent people. So they said, well, give us a better statute on testing, DNA testing, and we'll show you. Okay, I said, I'm not afraid of the truth. I want to know what the facts are. We're doing justice now. Let's see what the facts are. So we passed this bill. It wasn't the only thing that helped in the DNA testing, but it helped. And in 2002. Well, lo and behold, we did in Pennsylvania. We did convict innocent people of murder, people serving life imprisonment. One was, I think, was on the death row, and many other major crimes. That just shook me, that we were actually convicting an innocent person. And I said, okay, let's see what the reaction is here. And the reaction was, contrary to what my reaction was, their reaction was, and the public reaction was, I believe, was, well, it's better to convict a few innocent people than let any guilty person get away. Well, that's not the way I looked at it, because our founding fathers, John Adams, when he was defending the soldiers at the Boston Massacre, he used this phrase, and he said it's better to convict a few, to just the opposite, that it's better to let a few guilty people go than convict one innocent person. That's not the attitude of the public. And I think, but that didn't deter me. I mean, we're going to go ahead with it, but I was shocked that that was their view about it. So, but I didn't know how we were doing it. How were we convicting innocent people? Why was that happening? Was it done intentionally, which I doubt it very much, because I didn't see it in the DA's office that I was there, and they were no different than the other DA's offices. And so I had bumped into a law professor from Duquesne in a law school who taught criminal law, and he was at an event that he wasn't supposed to be at, and we just happened, and I wasn't supposed to be at, and we met. And so when I found out who he was, I started to ask him these questions. How do we do that? And he started to go over some of the data, the best practices about taking confessions, forensic evidence, eyewitness identification, double blind, and identification of the individual. And so that's when we start to proceed with those types of looking at that and see whether best practices, are we following the up-to-date best practices or not? And we were not. And in fact, there was a lot of resistance because it's hard to get people to change their ideas, change their policy, change the way they're doing what they're doing in the past because then it in some way infringes on them that they did something wrong. They didn't. They were using the best practices. I know when I prosecuted a burglary case, and when I was in the DA's office, and there were we used an expert on the tool markings on the doors, and that was great best practices then. There was nobody that challenged it, and I remember later finding out that that's not the case. At least now it isn't. And but it doesn't matter. We were convicted of anyway because we had a spurned girlfriend who decided to testify for us. So we would have convicted him anyway, with or without them. So I think it's so when I start to look at this, this is when I start these proposals. I've got a list here of the number of bills I've introduced and hearings we've had on all kinds of things. There's like 22 proposals on this: best practice of law enforcement, consolidation of probation and parole, human trafficking, which we're going to deal with soon. But it's a hard sell to get people to buy into this because it's counterintuitive. And while we were being tough on crime, violent crime was going up. So for those 20 years, from 2000 or 1980 until 2012, we had we started out with maybe 7,000, 8,000 inmates. And around 2012, we ended up with having about 52,000, 53,000 inmates over a period of that time. I asked my staff, well, let's look at this, and let's look at what was the population of Pennsylvania in 1980 as compared to 2012. How much did it go up? It went up about 3%, Pennsylvania's population, over that period of time. So let's see how about the prison population? How much did that go up? It went up like 350%. That doesn't make sense. I don't have to be an expert to say there's something wrong there.
I mean, I just really appreciate you sharing that evolution of your thinking, because in a lot of ways, I think that encapsulates what the Quattrone Center is all about with the systems approach, right? The idea that well-meaning people using the best information can do things But once we do that, we need to just, we can't just say, oh, that was the right decision and go forward, but we need to collect additional information. And sometimes as we collect more data and do analysis, what we find is that what seemed like a good idea didn't work out the way we wanted to. And, when that happens, we need to try and avoid blaming people, but look forward and say, okay, well, what is it that we're going to change in order to correct this situation and make it better? So I appreciate you, because I think that gives kind of a personal arc for the larger idea that we're trying to help people understand. And you've talked about a number of sources of error, and I want to get back a little bit to what David said earlier, and I'd be interested in some other folks' thoughts. So you made the argument, David, that it's really all these other types of error that we're talking about, eyewitness problems, Brady, that the defense attorney is kind of a keystone, if you will, in trying to deal with all those. So I mean, would others agree? Is it all about the defense attorney? Is that, if we wanted to choose one reform to deal with some of these systemic errors, is it about attorney representation, or are there other things we should be thinking about?
Well, just one thing that David pointed out was the difference between rural and urban public defender's offices. And I think that's true just about everywhere. I know David was talking about how many counties? 58 counties? No,
67.
67. California's 58 counties. We're 17 counties in Nevada. But the law in Nevada says that in counties over 100,000, there must be a public defender's office. That's 2 cities. That's Las Vegas, and that's Reno. In the other 15 counties, there are not public defender's offices. And what that leads to is no social workers, no investigators. They're appointed by the judges, local lawyers who are friends with the judges. And I've also seen situations when we've looked at rural Nevada where if a lawyer goes to trial too often, if she brings too many motions, she's not appointed anymore. And we need much more oversight in these rural areas. And I sort of get the sense that in Pennsylvania, you have somewhat the same. I doubt that there's a law that's saying you only have to have a public defender's office in certain jurisdictions. But when I go to meetings of other chief public defenders, it seems like there's always that battle between those of us in urban areas and those of us in rural areas, although I guess you're the exception because you're pretty rural. And
there's nothing rural about New Orleans.
Yeah.
Nothing rural about, but we have rural counterparts, of course, around the state. And I think, to the question of what reform do you do, and also backing up a little bit because, I'm a bit cynical in this work. I don't think everybody's well-meaning. I think some folks are actively malevolent in our system, and it's not just my clients, right? I think that's actually true. I think there's folks who know the bad things they're doing, and it's a cost of doing business for political gain or to achieve public safety, and I think that is a tragedy. And to the question of if you do a reform, is the most significant reform, most important one, public defense? And I think inside our system, it's gotten so large and so lopsided that I think you do need to have a defender organization that can stand on equal footing with other members in the criminal justice system, with other stakeholders, and doesn't have to play handmaiden to courts, so they need their independence, and they need stable, adequate, and reliable funding. One of the unique features in our system is how we're funded, and we need structural funding reform in Louisiana, and I would suspect a lot of places, but nowhere do you have a user-paid criminal justice system like you have with us. And by that I mean we depend on fines, fees, and costs paid by our clients to fund our system, largely fund our system. On average, 2/3 of public defender budgets come from these fines and fees generated through the court system. No other public defender in the country depends to that degree on fines and fees. And fines and fees are in everybody's system. So I don't want to be misinterpreted as New Orleans is the only place with fines and fees. Anyone who's had a traffic ticket knows you got fines and fees in your system. But we're unique insofar as we expect that to pay for the system. And we expect the poorest and most vulnerable in our system, because make no mistake, our criminal justice system is not a system of general application. It is aimed and pointed at poor folks, poor people of color. That's who my clients look like, and that's largely, certainly if you're in an urban area, what your clients are going to look like. And they're not going to be able to pay the fees. And our structure is so perverse that we often, as a part of meeting with our client, have to build rapport around the structure of our fee system, because we'll have clients and their families who will tell us, you know, we don't trust you, you're in cahoots with the DA, and you get paid when we lose. And they're right. On paper, they are absolutely correct. There's a $45 public defender fee that they have to pay if they're found guilty or plead guilty. If their cases are dismissed or there's an acquittal, they pay nothing. And by the way, we depend on all those fees. And there's a few things that happen in our system. If you're arrested and you're eligible, you owe me $40. That's the application fee. If you go and you're adjudicated, guilty, if you're found guilty, you owe me another $45. Not to mention what you got to pay to the judicial expense fund, any fine on the charge. All those will get stacked up, right? And so that's a problem. And if you had a public defender's office that can live up to its highest calling, that which was propounded first in Gideon and has been echoed in other opinions, that is, do justice, be a part of a system that does justice. And in fact, defense was deemed fundamental to justice in our system. If you have public defender's offices who can live up to that obligation, that call to protect innocence, defend the Constitution, and hold power accountable, I don't think you have the same kind of system you have now. I sincerely believe if we had been around and resourced to do our jobs in the most ambitious way thought of through our Supreme Court opinions, then we would have a different looking system. And the fact of the matter is, we did not do that as defenders. We watched things like in Louisiana, burglary charges that can result in a mandatory life prison term. Your third burglary is you're a triple lifer. And if you're found guilty, you'll go to jail for the rest of your life. You'll have a habitual offender statute that requires no prior violent offense. That's Louisiana. You'll find a state that leads the country in incarceration. And it's not a coincidence, I don't think, that traffic tickets, because if you're depending on fines and fees, your highest volume court is your biggest funder. It's not a coincidence that the public defender's office cannot stand up as all this is proliferating, because we're depending on traffic tickets to keep your Sixth Amendment rights alive. That's ridiculous. And the other piece of that, as practitioners, we all went to law school learning about, we were very high-minded, right, in law school. And I love watching Supreme Court justices get appointed. And there's nothing wrong with Gorsuch as an appointee. I mean, I wouldn't have picked him. But it's fun to watch. To us, it's sort of funny to watch these folks who are going to make incredibly important decisions about the lives of people going through our system who don't have any insight into our system, who didn't practice, who don't know that there's a judge who will tell you, you grab that book and I'll hold you in contempt. And that book is the Code of Criminal Procedure for Louisiana. That we have judges who will say things like, oh, I see you like, this literally happened, a discussion where they're talking to the client, and the client is saying he likes, asking him about what vodka he likes. Now, it's inappropriate to begin with, because he's in a substance abuse program, but he's like, well, vodka he likes. And he tells him, you know, Grey Goose or something like that. He's like, oh, I see you like the foreign stuff. That explains why your lawyer is Miss Tina Payne. Like, he said that. That's on the record. And what happens in those instances? Nothing, right? And that's because we need the resources to have that counterbalance, because it's gotten sort of out of control in that particular aspect. And no one, I just heard this song, you know, recently, and no one knows it but me, is how you feel a lot of times as a public defender. And in our office, what we do as well is to try to be that counterbalance. And part of doing that is building constituency, because the reason why these things happen, there's no constituency. So we engage the public, because I don't think they really know what public defenders do on a day-to-day basis. And it's allowed us, for example, to leverage more resources and be able to have a better reputation in our community, which has helped our representation. Since becoming chief, we've done a lot of part of what we do is use culture as affirmation. So we've had second lines. If you don't want to know what a second line is, it's a walking parade in Louisiana with a brass band. Quite fun, by the way. We've had second lines. We've done community events. We've sponsored spoken word on the criminal justice system. And all of that has built constituency. It's allowed us to tap into our community and mobilize our community when we need them. And that has changed legislation that has built revenue for us through seatbelt tickets. I hate these fines and fees, but it's the landscape I got to run in. We get revenue through seatbelt tickets. No other public defender gets that. We get revenue from traffic camera citations. I know everybody loves those, photo enforced tickets. We get $5 on every one in Louisiana. We're the only public defender that gets that. We now receive a regular appropriation at the local level, about $1.5 million. No one else achieves that. Because we have made it so that politically there is a consequence to fighting us, whereas previously there wasn't. And so I think it all cascades from being able to create a public defender's office or a public defender system that stands on par with the other actors in the system and decision makers, and making sure that it's resourced and funded to hold that obligation. I think that is a significant reform.
I'd love to hear your responses, other panelists, to that. Yeah.
So, particularly that last point, I mean, for me, sitting here, it's we don't have to convince ourselves of the seriousness of the problem, of the underfunding, high caseloads, inadequate resources. Really, the challenge is how we change the system. And I think a lot of good models out there that work. We've heard discussions about collaboration, for example, in Las Vegas, where different players in the system get together and say, wait a minute, we got a problem here with the local jail. Maybe we could solve it together. Doing the same thing in Philadelphia now with this MacArthur grant and reducing the jail population here. Everybody involved, judges, prosecutors, probation, defender, mayor, had to get on the same page on that to get funding and commit to a 34% reduction in the jail population. Will we reach it? Maybe. We're halfway there. But that's a way in which people can be convinced that if everybody in the system works together, it actually works better. The outreach that you've done in New Orleans to the community is really important. So people understand the worth and the value of the defender and the essence of fairness that it brings to the system. What I'm struggling with is, how in this country where politically all the winds are against us on a lot of these issues, particularly with the new administration, even though we're kind of coming together a little bit on issues of mass incarceration and so on, how we sell people on the idea we've got good models, they work better, you have better defender officers, you're going to have better justice. They're the ones who are going to uncover corruption. They're the ones that are going to be able to see what best practices really are and propose them. A lot of them come from good defenders. They can litigate those issues. So what kind of combination of interventions do we need? There's litigation, right? There's trying to community building. But we really need a more coherent strategy on how to change what is really a corrupting part of our system that people see but don't really care about.
Other
Couple
thoughts?
comments.
Yeah,
One of
please.
the reasons why I wanted to come here is not to necessarily, the gentlemen, as I said on the panel here, have more experience in what they're doing now than certainly I do. But what I wanted to be here now is to talk about advocacy. Because one of the things when I was looking at how do we stop convicting innocent people, I asked my staff to look at other states and what they had done, and there must be some common, and when the ones that were successful, and they came back and said there was none. They just introduced a new piece of legislation, a reform piece of legislation, and they have less people in their prisons, and they're going in the right direction of not increasing people in prison, but going the opposite way. And so I only conclude was that it wasn't the legislation that we were passing, but it was change in the attitude in the community, in the law enforcement community, with the judges, the prosecutors, and everyone else is associated with it. And so, and that deals with advocacy. I've been involved in enough reform issues over the last 30-some years I've been in the legislature to know that you don't start out with everybody liking what you're saying to them. But if you have the truth and you advocate for it, they usually come around. And I think the most important thing that we can do now is this is important to have this conference and have the talking about it. But we know what the solutions are. They're just not popular, or it's just not, or the legislators don't feel comfortable in voting for it because they'll think they'll lose. When they vote for some of these things, they look at the time they're going to run for re-election, and they'll get mailers sent out to every voter in their district, saying that they're soft on crime or that sort of a thing, and they don't want to do it. And it goes both parties. I thought when I got involved in this, I'd have the Democratic Party really behind me. They were just the same as the Republicans. They didn't want to touch it. That's changing in both Republican and Democrat now. I'm in a battle now with the mandatory minimums. I was the author of them, but we're trying to change them, and they're trying to reinstate them. Law enforcement's trying to, and so we've had battles in that are. So it's all about, and every one of these 22 proposals are in different degrees of being passed and not being passed, but it's going to get easier because there was a poll just taken in Pennsylvania, and so we've basically gotten to a point where I think the public is behind us on these issues, because the poll indicated both Democrat, Republican voters were like 90% favorable of criminal justice reform. And they had numerous questions answered, and continually be in the 90%. I don't know many polls that get up to 90%, especially on that issue. So I think we've got the public attention. So this is the opportunity of a lifetime to advocate for it. We don't need to talk about it anymore. We know what the solutions are. We know what has to be done. Now let's get the public on, and the legislators and make them feel comfortable they're not going to lose the next election by voting for this stuff. And so advocacy is what I think everybody here has contacts that they can reach out to. The center has contacts and use their influence. You should be up in Harrisburg. If we want to get it passed in the legislature, every time I introduce a bill, I have to compromise it with law enforcement. And so it gets watered down, but that's the way it is there right now. But we are at a point where the public is supportive of us, so we can get this legislation passed. We need your advocacy. We need you to communicate with your legislators. We need you to communicate with your fellow members of your business or whatever areas you have influence. Be up in Harrisburg and start visiting them, or send letters to them, or calling them, or do whatever, making them feel comfortable that it's okay to vote for this.
Senator, you're right. The narrative has changed to some degree, right? I mean, there's kind of agreement right and left on, we prison too many people. It's sometimes unfair. We've got an innocent movement that has shown a lot of innocent people being convicted, and people get upset about that. And as Zane said, there is a way of changing the narrative, right? Even the Department of Justice was able to kind of change course and say, wait a minute, maybe the numbers aren't really the way the right metric for determining, whether prosecution brings public safety. There are other things to do. So the general narrative has changed, which is why I think you see the polls changing. But that doesn't speak to this problem. And it doesn't speak to the problem to say we need good defense lawyers just to protect innocent people. That's a margin, right? I mean, it's terrible when an innocent person pleads guilty, right? Because they're told, well, you plead today or else you wait 6 months for a trial. That's terrible. It's almost equally as bad when a guilty person does that and doesn't get a fair process, right? Doesn't get a good defender. I mean, I think we've got to drive home that fundamental point and not just kind of pick, the easy fruit, right? The innocent person is out there, right? What a terrible thing. That's not going to get defender offices good funding.
I don't mean to interrupt you.
Yeah.
But then there's no silver bullet. We all know that. But a lot of the discussion yesterday was about bail reform. We've worked 2 years in Nevada, and we are nowhere. We're absolutely nowhere on getting any kind of bail reform. It is so rare that one of our clients gets OR'd. It just doesn't happen. And that, to me, is the biggest problem, is whether innocent people are pleading guilty or guilty people are pleading guilty to things they should not plead. It's because the prosecutors are smart enough to realize if you offer my client an OR, he'll plead to just about anything, no matter what my advice or the attorneys who work with me, what their advice is. Because being in jail just sucks. There's no other way to put it. Our detention center is relatively new, and it just sucks. You never get outside. It smells terrible. The diseases that are rampant in any detention center are so problematic. And we've worked 2 years on this, getting to talk to Spurgeon Kennedy again yesterday, who came out and spoke to us a year ago, January. And we've worked so hard on this, and we are nowhere. The prosecutors are very uncomfortable in reducing bails. We not only do we have high bails and have a standard bail system in Nevada, which we have to sue at some point against, but in Nevada we stack our bails, and I suspect no one else in this room has that. If you're accused of burglary, possession of stolen property, and whatever the third triumphant is, theft, you're looking at $30,000, $20,000, $20,000. You are looking at $70,000 in bail before we finally get to a judge, maybe 3 days later, more likely 10 days later, and maybe get it reduced to $10,000. I've told a few people in here a story about how last week we had 3 low-level misdemeanors, the lowest of which was a woman she didn't steal anything. She walked out of a cab for an $8 cab ride, and the judge kept a $1,000 bail. That absolutely should have been an OR. And I don't know why the court did that. She's a good judge. But so this, until we get true bail reform, where people get out and get to make the decision of whether I should plead or not based on can I get out, but did I do this and is this the right deal? Because right now, when you're stuck in jail and you're there more than 3 or 4 days, you're losing your job, you're losing your apartment, you're probably losing your boyfriend or girlfriend, and you probably lose your dog too. And all that is really, really crucial to our clients, and they're making decisions that we don't recommend. We plea bargain a ridiculously high percentage of our cases, higher than I want to admit here, but they're not forced by lawyers in our office. They're forced by the circumstances our clients are in.
I mean, yeah, thanks for sharing that perspective, and I wanted to hone in on a few elements of what you just said there, Phil. I thought it was really interesting. I mean, to the senator's comment, having spent some time thinking about bail reform and, been involved in different jurisdictions, I wonder if maybe this is one of those issues where the process in Nevada is going to be a little bit longer. I mean, I think if you had said to people in New Jersey, hey, if 3 years ago you had said, hey, today there's basically going to be no more cash bail in the state of New Jersey, people would have said, well, nah, that's insane. Yet, here we are. But another element that I wanted to, kind of hone in on is, you mentioned a little bit in fasting, we need to sue at some point. And I want to hear people's thoughts. David, you've been involved. So we've talked some about advocacy, changing public opinion, going the legislative route, but then there's also, litigation, right? And I know in New Orleans there was some efforts to litigate over the situation there. How does that fit into this puzzle of getting the reform we need here?
Well, I think litigation, one thing lawyers have to learn, and one thing I think lawyers have to learn, and what I teach in my office is litigation is not a good unto itself, but it is a tool that I think you can't be afraid to use. And particularly when you talk about large systemic reform, I think that the model we teach and when we sit around as a leadership team about systemic reform is we look at a sort of 5-pronged strategy to any big change we want to make. So we look at we look at media. What kind of communications and messaging do we need around this? Who needs to be convinced? Outreach and public education go together with it. Legislative advocacy, which I would say is probably, if you're successful, the most permanent and most lasting kind of change you can make. Folks don't like, once you have a big legislative change, tinkering with it. And then there's litigation. We always look at a litigation prong, and we have a special litigation division in our office that looks at a lot of our practice issues, but also thinks broadly about these big systemic issues. And I think having partners or being able to launch litigation yourselves as a public defender office is important. Litigation is the way we see ourselves being able to throw a punch back if one is thrown at us, so that we can do more than write a strongly worded letter to whoever did us wrong. We sue, and I came up, I started my career suing people, and I joke I love suing people. The reason I became a lawyer was, we grew up poor, and we grew up poor in my household. And what my mom would do is we'd run from house to house as she could afford the rent. And we'd get out just before we were evicted. And there was one time when my mom's on the phone, she's stressed out, she's yelling, she just needs more time, she just needs more time. And a couple days later, I'm home from school, and all of our stuff is taken out of our house, and it's in our carport, it's in our driveway, including a great old stereo system, which most of y'all are too young to understand, had a great 8-track system in it, had a number of 45s, They couldn't even be bothered to bring it out all in one piece. It was in 3 pieces. And I remember in that moment that people just don't listen to poor people, but they listen to lawyers. If I write the complaint and I file it, you've got 20 days to answer. If I give you the subpoena and you ignore it, there's a warrant for your arrest. I like that. Generally speaking, when you are that voice for poor and vulnerable people, as we are as public defenders. And so you cannot discount the power of literally going into court and forcing the issue. We're not going to have a committee to study it. We're not going to have a task force with a report that's going to get buried. We're going to go into court, and somebody's going to make a ruling up or down. And we're going to take that ruling if we like it and enforce it. If we don't like it, we'll appeal it. And it's going to be a real fight. So I am a firm believer in litigation, in systemic change, and as a part of a broader plan when you've got some action you want to change.
David, yeah.
Yeah, so, and there are some good examples where litigation actually has created change. New York State, same kind of litigation we had in Pennsylvania, a case called Harrell Herring a couple of years ago. State, and it was actually a suit against the entire funding system in New York State outside of New York City. The New York Court of Appeals said you could sue again pre-trial based on systemic flaws. It forced the legislature to appropriate more money as a result of that, and the state agreed to, build up public defender offices around the state. That was successful. There have been half a dozen states I've said they've done similar things, but it's a kind of jurisdiction by jurisdiction approach. But I really think I think it's critical. It's if you can. Listen, if you're in a jurisdiction where you can have discussions with legislators and reach some agreement, we have it here, we have it in some other large urban places where people understand and you get, if not fully sufficient funding, enough to run a good defender office, that's fine. But I think we've got to convince also public defenders like yourselves to take some risks. There are too many public defenders who are appointed and they're sitting there knowing that if I really do, create problems here and push too hard, I'm out of the job. Well, I think that comes with the turf. When it gets to that point, that's what they've got to do. Al Flora did it. He sued. He won. Did he get fired? Yep. But I think in this kind of job, you just can't sit there and say, well, the status quo is okay, right? Maybe they'll give me a few more dollars. And it's not the only prong. I'm looking for some kind of uniform approach, right, that can address this, not just in one or two particular counties or states, but that gets some kind of national movement, and ultimately an understanding, like we've reached in other areas, where public opinion flips, because now we have an understanding, right, of the critical need of defender services, and to use those jurisdictions where we really see progress, because there is a kind of a partnership, that's real in the system, that the defender is part of, and what they're able to do on a day-by-day basis. If we don't do that, we're going to be back here in 10 years and we'll be kind of talking about the same issues.
Well, I think that your participation and comments on today's panel, I certainly feel like for me, they've helped to increase my understanding. I want to give those in the audience an opportunity, if there are folks who have questions for the panel, if you'd like, panelists, if you'd like to go up to the microphones and share your questions, we can extend the discussion that way. So yeah, please.
Yeah, I have a comment. I was listening to Zane's presentation earlier, and then your comments about all the plea bargains that you are in a tough situation to negotiate because of the circumstances surrounding bail. And I was just wondering, maybe we need to ask the question, have our prosecutorial and court practices and procedures actually have caused poverty? Everyone knows what happens after a person takes a plea, in terms of what happens to their families, their jobs, whether they can get apartments, whatever. And when you take a look at the statistics of how much plea bargaining is occurring percentage-wise in specific metropolitan areas, and then you take a look at the amount of prosecutors in a specific city and how many indictments they're producing, how many pleas they're getting. I'm wondering if maybe the bigger discussion might be, have our practices caused and specifically contributed to poverty? Because if we understand that better, and there's a cost to how we then remedy poverty, maybe we could make a nexus between both, so that the legislatures and the people who are involved in criminal justice can apply a more comprehensive solution to bail and other things.
In answer to your question, when I say Las Vegas is unique, it is incredibly unique. Because of the gaming industry and because it's really the only industry, they wanted to clean up the gaming industry, and we were laughing about corruption, and I think it was taken out of context, but I'm sure you have a question about that. So much so that what happened was to get essentially any job in the gaming industry, to work in the pit, to be a cocktail waitress, to be a bartender, to do just about anything in gaming, you have to get a sheriff's card. That means that the sheriff of Clark County gets to decide whether you get this card and whether you get to work. And it's certainly based, the denial, there is a way to appeal a denial by going to the city council, and you and I have talked about the city council. But it's based on priors, and very rarely are those decisions by the sheriff overturned. So where your question is valid in every state, where I live, it's unbelievably important, because if you have that felony conviction, you're not getting a sheriff's card and you're not working, and I can guarantee poverty, and that poverty can basically guarantee recidivism. So there's a lot of things we need to change. Where I live, it's acute.
I wouldn't, it's not plea bargaining per se, right? Everything you're talking about will happen as a matter of collateral consequences if someone's convicted after trial. I'm not against plea bargaining. I think in a lot of situations it's not an unfair process. If there's equality, right, in the resources on both sides, you have time to investigate the case. You reach an agreement after fully, litigating motions and so on and so forth from the defense side. It may be perfectly appropriate to talk about plea negotiations and resolve the case that way. It's in a lot of people's interest, so I'm not against that process. I'm against that process and what you talk about the consequences that flow on a totally uneven system, right, where it's stacked in a way that compels people to plea without even the kind of investigation I talked about or understanding of the case. That's the problem, and that's where the resource disparity, I think, bites most deeply.
And I would also say that the process does not cause poverty, as you put it, but it deepens it, because we have to remember that the system is aimed at the impoverished to begin with. And so to then find, to have and place the additional burdens and obstacles in front of folks with a lot of burdens and obstacles, you can actually deepen poverty. You can deepen a whole lot of problems that are presented as folks come in and through the system. But I think, to David's point, you can't divorce it from a larger system. The proliferation of collateral consequences has to be looked at, because it's not, the process itself isn't inherently wrong or bad, but the way the system has been built and the rules that are at play right now creates a heavy, high percentage of pleas. If you're a public defender office with a 2% trial rate, you are considered a trial office in the United States of America. It's like, oh my God, you're a trial office. I'm like, there's 2%. that go to trial. And one of the things that we see just in our sort of efforts to control workloads, we actually do go to trial more. And last week, I had 3 of our trial teams in trial simultaneously, all with clients facing very serious consequences. And we were very excited because we pulled a hat trick. We had 3 not guilties all come out at the same day. But it was one of those moments when I looked up and I'm like, if you've got the resources and you're ready, then you can change the dynamic a little bit. And the idea that you can do that as an office feeds into your negotiation. It's like, all right, we're not afraid to go to trial. And you'll have a client and the district attorney look differently at what the offers are when you can make that, when you can say that and have it be sort of credible.
I can also add to this that in a lot of the minority communities, the head of the household is in jail. And as a result, you have a system in which children are being raised by grandparent or the grandmother. How many times have you seen that reported? And it has a terrible impact on, that's poverty, because we've taken away the family, the basis of our community. The head of that family is not there. And we were looking at this on regard to children of incarcerated parents. And we have to address what's happening to those children. And when they see that their parent is in prison, some of them will say, you know, I'm going to be there someday too, because they were looking up to them. They actually said that. And so it's important for us to be concerned about the process, about how we treat the children, the family members, when that individual is arrested, and how we deal with them going forward is an important thing, because definitely if we're talking about poverty, that's a driving force in a lot of the minority communities, and in other communities, particularly the minority communities.
Oh, let's take a question on this side.
My name is Mike McLaughlin, and I spoke with Phil and Senator Greenleaf yesterday. So a little bit of banter back before Phil and I we were debating, is Las Vegas more corrupt or is Philly more corrupt? So if you're not from Philly, Chicago, somebody says Chicago, it's just, you know, this is not like made up nonsense. I'm not getting on a microphone and saying, look, this guy is just like making up things. It's not verifiable or vetable. I say Google, Bing, and Yahoo verify these things. And Mr. Rudovsky's here.
So I'm going to invite you, so
Yeah.
do you have a question?
My
related
question's
to the
about the
indigent
PCRA.
defense?
Okay?
Yeah, sure.
And
about
this
the
is Senator
PCRA?
Greenleaf specifically, because he was the author of it back in, I believe, '95 when it passed. And I was in a long panel earlier about the PCRA. The PCRA Post-Conviction Relief Act is how you get back in court collaterally, okay? So it's kind of ludicrous because right now, as the law stands, and the Senator could correct me, you have 60 days from the date you find out something to act. So in other words, if there was hypothetically an article in today's Daily News or Enquirer about a man who confessed to committing a crime, and a guy's doing life in Pittsburgh, but he was from Philly, but he shipped him out there. The district attorney's office, if this guy acted on July 1st of this year and said, well, listen, I found out about this article on July 1st because somebody brought it to my attention, the DA's office say, wait a minute, you had 60 days from the date the article was published, and you didn't find out about the July 1st, and we count the calendar days, you're like 6 days late. So this is like on the face of it, it's like if you dropped off your child for daycare and you came 5 minutes late and he said, sorry, didn't you see the sign at the window? Your child was farmed out to
So maybe one of the way we can think about this is how to, you know, this issue of kind of adequate funding, how does it feed into kind of post-conviction proceedings and those issues? If there's anyone who'd want to talk about
Just very
that.
quickly, I mean, there's a lot of problems with post-conviction, obviously. Pennsylvania's got one of the most restrictive acts, 60 days to file something after you newly discovered evidence of possible innocence. The Senate has been trying to work on that. There are proposals to extend at least to a year. We've had difficulty doing that. But putting aside that, which is certainly a significant problem, there's just the same problem at post-conviction we see at trial in terms of adequacy of lawyers, what they're paid. Those are often private lawyers who are then paid not enough to really challenge that. We see it on the appellate level. I mean, this is not just trial work, it's appellate, it's post-conviction. The lack of resources on the defense side, I think goes through the system.
Okay.
Senator, did you have anything that you wanted to?
Well, what we're
say?
doing now is we are looking at that and trying to increase it to a year, but it's a battle again. We have to have the support and the public support and advocacy for it to get it passed. And I think a year is pretty modest, actually, in that regard. So we have a bill, and we're trying to get as much as we can in regard to the time allowed to raise those collateral issues. But it all has to do with advocacy.
And I imagine that many would agree that even with the extra deadline, without the adequate funding, the two kind of go together. You've got to have the resources to be able to pursue the cases. But yeah, thanks for.
But also, in this, going back to the original purpose of this panel, was in regard to indigent defense. I introduced the bill last session on that, brought it up, and the committee basically told me they don't want to deal with it, that they have to balance a budget and they're not interested in dealing with it, so we didn't bring it up. So I introduced it again. I don't have a lot of good qualities, but one quality I do have is perseverance. And so I introduced it again this session, January 16, 2015, referred to my committee. And I said, before I bring it up, let's check with the members of the committee and see what's going on, rather than going through that whole thing again. And the response was completely different. I was surprised. Because of these court decisions in Pennsylvania and the right to sue and giving them a cause of action, they want to deal with it. And I think that we might have a chance of actually passing it. So we are going to bring it up. We may even hold a hearing on it to refresh and also to point out the litigation that's been occurring on a state level and a federal level about providing adequate representation to the indigent defendant. And so it has changed. And the other question you asked about monies, we're also even trying to get a bill passed that would allow compensation for wrongfully convicted individuals. I keep telling him that my colleague over here, if you don't do it, he's going to take you to federal court and get a multi-million-dollar. So take your poison. You can have a liquidated damages, but we're having difficulty with that because of our budget needs, and they don't want to spend their money on that. But that's, I think that's foolish. But right, sure.
Thanks. Yeah, Frank, please.
For Derwyn primarily, but for the others as well. Derwyn, you made a very courageous decision late last year to publicly announce that your office was not going to handle any more felony cases because your office was overwhelmed and under-resourced. I was wondering if you could share, do you believe that move that you made has had a positive impact? Were there any collateral damages? And can you see it as the beginning of a movement nationwide for PD offices to collaborate and bring more attention to the crisis in underfunding of this important public service?
The decision itself was incredibly difficult because no one becomes a public defender to tell poor people, no, I can't help you. And in terms of collateral damages, the collateral damages were the clients left without representation and making the decision that there's too many people for us to ethically, professionally, and constitutionally handle. And those are real consequences. And that brought a good amount of heat from different parts of our own sort of usual suspect community, grassroots organizations, inside the organization, It's better to have us than not have us, sort of thing. But I always felt like that's how they held public defender offices hostage to begin with. Well, if not us, then everybody's going to lose or be in tougher shape. So we had to take a long view of it. And I think in taking the long view, I think, yeah, it was the right thing to do. I think it was the right thing to do on the law. I think David spoke to the ethical, the idea that we are a standardless practice permeates public defenders' offices around the country. Like, you're a speed bump on the way to the penitentiary is essentially how a lot of us are viewed, and that's just simply wrong. There are ethical requirements, just like every other lawyer. So I think the long view was the right one, and what it's done for us is it's brought not just attention but some action. We did get some increased funding at the state level, some increased funding at the local level, and I think it helped to create an urgency for broader reform when folks realize you have to either provide more resources or shrink the system or do some of both. So I don't know how it's going to catch on around the country. That certainly wasn't our intention. We're not trendsetters. I've never been fashion forward in that, so I certainly don't expect that. But we believe that more public defenders, and more public defender chiefs in particular, need to get out of the mindset that we simply have to do this. We have to take all comers, 1,000 cases, 2,000 cases, whatever it is. It's our job to handle all those cases. It's our job to represent people constitutionally, ethically, and professionally. And I talk about it as the triangle of defense. On one side, you've got your ethical obligations. Another side, you've got your constitutional obligations. And on one side, you've got professional standards. And to the extent your cases fall outside of that triangle, you've got problems, and you're going to have to take some actions to deal with them.
Please.
Yes, I have a question for the entire panel, and it has to do with the funding of indigent defense generally. I've seen some jurisdictions take funding that would traditionally be used for either public defenders' offices or court-appointed counsel, and because there's a limited, finite number of resources, funnel those towards diversionary programs, maybe even within a public defender's office, social workers, things of that nature. And I understand that. There's a trend towards a holistic approach, let's decrease the number of people involved in the criminal justice system generally. But then the flip side is that each public defender per capita sometimes sees an increase in their caseload. So I guess, how do we speak to that generally, given the finite amount of funding for criminal justice reform? Where do we send it? Do we put it back to what we think of as the traditional defense attorney role, or do we send it towards other resources?
Derwyn and I spoke last night. We both believe very strongly in the holistic approach to indigent defense. I guess I don't buy your concept that there's a finite amount. I think funding sources have to understand that the way we did it 30 years ago, where you had a public defender, maybe an investigator, maybe a secretary, that's not the way to do business. The way to do business is to have social workers and to have those diversionary programs and those people who can be diverted from the system, from going to jail or getting a conviction, and can get drug counseling or get into the mental health facility they need to be in. That's the right way to do it. So that's why more fund. I know what you're saying. Most funding sources will tell us there's a finite amount, but I don't think the finite amount that's been historically established is the right finite amount, and we have to do more for people. The jail that I work with tells the county that 30% of our inmates have a serious mental health problem. I think they're underestimating by at least 10% and maybe 20. and they're not getting the help that they want. The jail is not the place to get it. So we need a more holistic approach. It shouldn't be at the cost of attorneys who work in my office. It should be in conjunction with. And I won't take anything less.
Please.
Could the panel address whether or not it believes that there ever is a likelihood that there will be sufficient resources to provide the highest quality of legal representation for defendants? And if not, is there a time to consider whether high-quality representation could be provided, say, to the most serious crimes, and an alternative system arranged to deal with other cases that would provide a quicker and more equitable solution to our problem?
I think the only way fairly to do that is to say for those lower level cases you're talking about, keep them out of the criminal justice system in the first place. And I'm not talking about diversion once they get in. You still need lawyers for that. You need good lawyers to do that. You know, in this country, we ought to be moving the other way than we have been in terms of criminalizing virtually everything that we don't like, and think, you know, drugs, alcohol, you deal that as a health problem and not as a criminal problem primarily. But I don't think you can divide the world, quite frankly, between serious cases and so-called non-serious cases, particularly in a world of collateral consequences, in a world of Ferguson policing, right, where counties depend on those fines and costs, right, to not only for their criminal justice budget but for their general budget. So that's, you know, I'm not sure that's the answer. You say, are we ever going to get to the point of very good representation for everybody? We won't, even if we did everything that everybody in this panel wants. No system is going to be perfect in this country. Health, education, certainly not the criminal justice system. But it is so uneven now, right? I'd be satisfied with some modest progress in the next 5 or 10 years.
And, you know, I do think there are some models that maybe are a little, you know, David, you mentioned the federal defender system, and again, no model is perfect, but, you know, I think many people might think that's a model that gets a little bit closer to, you know, a little bit more reasonable situation.
Sure, yeah.
Well, maybe I'll add a little bit to that. Help is coming. The Supreme Court decision that was mentioned previously by David, and coming out of Luzerne County, I have a copy of it here, all 65 pages of it, and they basically gave the individuals themselves and the public defenders the right to bring a suit to ask for adequate funding. And that's coming because my chief of counsel in my office for the Judiciary Committee keeps an eye out for right-to-know requests. And there's a whole slew of requests going through since this decision on the material in each of the counties in Pennsylvania and what they're spending and that sort of thing. There are people out there, I'm sure, now building their cases for lawsuits against the counties to provide more service. And that's coming. And it will end up in our courts. And I think you'll see, there was a document that was circulated here about Pennsylvania. It's a whole list of people and states and what they provide, and many of them provide 50% or more of the states, and Pennsylvania's out there on the right with no support. The Commonwealth does not provide any support. It's the county who provides that support. That's going to change. There's going to see change going to happen here in regard to funding for indigent defense in Pennsylvania.
Yeah, why don't we take one last question, please?
Okay, just as primarily directed at Derwyn and Phil. Derwyn, you alluded to this earlier when you talked about some of the ways in which you can slow down or reverse the sense of cost imposition, numbers, right? And I wonder if you could talk a little bit more about some of the other things short of trial strikes, which have their own obvious set of ethical problems, that your office has been able to do in essentially saying we are too large a group of defendants and we can slow the process down unless we get some of the accommodations we're looking for. Because it's my sense that since Katrina, you've been able to use numbers and the number of cases in some senses to benefit you and obtain more process.
Well, first I have to acknowledge Pam as also being on 60 Minutes. She represented Mr. Donald Gamble in that segment. We use numbers and data. We use numbers and data as a way of compelling, we wrap stories around them. And we use that in our funding advocacy. We also use it as justification for action. I like being evidence-based in my decision-making. I may be alone in that, in my jurisdiction. And so some of the things we've been able to do is provide different kinds of advocacy in different, at the state level, at the local level. It's also allowed us to take a look and control our workloads in ways we haven't before. We keep time in our office as well, and we monitor people's workload. And I think that has actually paid some dividends for the clients we are able to help, but it also shows folks that we are not powerless in the system. And so we are able to stand up and take some action. It's fortified by data that we have and sometimes that others don't. We've been able to do that through our refusal of cases, controlling workload, participating in jail reduction, all different things. We keep track of, visitation, and it's powerful. It's powerful to community. It's powerful to everyone who pays attention. We keep track of jail visits, for example. And we tell folks we need to go to jail, and they're like, why do you need to go to jail? Well, because our clients are there. But I think we average, and I don't get all my lawyers putting it all in all the time, but we average over 6,000 jail visits a year in our office. And folks never knew the number. They knew we were over there. But when you say 6,000, folks are like, wow. And it's funny because it's the Deep South. So I wrap that around the story out of Matthew and Jesus looking at his followers and saying, because when I was in jail, you came to see me. And it is a moment of inspiration and motivation for my staff, but it also moves a city council or a legislator in ways that if you didn't have it, you wouldn't be able to do it. And it buys you time in making some decisions and making some policy changes.
Is David ever in the room? Oh, good. We have a pretty good case management system. We had one of the first in the country. And at the time, I was working against a DA who was, to say we were adversarial is a joke. We didn't talk. And he truly believed that all the work done in the criminal justice system was done by them. We did nothing. He would literally tell the county that we have 30% of the cases when we're somewhere between 64 and 66%. And just always accuse us of not doing anything, and it went on and on and on. And it's hard to give county management access to everything we do. It was really counterintuitive to everything I felt. And when this battle was going on, and our county manager is a lawyer, we talked about it, and I said, you know what? You can have access to Justware. Here it is. They can't look at individual cases because it's privileged. But every case we have, every case we handle, every case we conflict off on, county management knew about. So they knew exactly what our caseload was, exactly how many death cases we had, which was too many, I admit. Everything we had, everything we did, every jail visit we did, they knew about. And so when the DAs would go to the budgeting sessions and tell them how hard they're working and how lazy we are, the county just knew every case we had. And it was probably one of the best decisions I made, and has really led to our cooperation and our working together on the jail and everything else, because they know exactly what we're doing. That was so hard for me to do it. I don't know why, but just to give county access to everything we do other than the notes that our lawyer puts in Justware as to what they did and the conversations they had. And boy, has that worked for me. And I would recommend that to all public defenders. Let the county know what you're doing. Let your funding source know. I mean, if it's the state or if it's county or city who's ever doing it, it really changed my relationship with the county.
Well, please join me in thanking this wonderful panel.